SJC-10834, Commonwealth fee, Amaral Montrond.
Good morning, Ms. O'Brien.
Good morning, Your Honor. Good morning, Your Honors. May it please the Court, Leslie O'Brien for Amaral Montrond. As the Court knows, this case was originally argued some time back before the Court, but the Court decided that an evidentiary hearing was necessary as to a couple of issues in the case. One of those issues has essentially been resolved between the parties. That concerned whether there were telephone records to confirm that a phone call took place between an important witness, Kenyisha Cheney, and the deceased, Carlita Cheney. Those records were filed in the Superior Court. They were located apparently in a detective's file and did confirm that there was a phone call, although a much shorter phone call than the witness testified to. There was a phone call of approximately 13 minutes beginning at 11:30 p.m. So that issue essentially the parties have resolved. The remaining issue is a claim of ineffectiveness by Mr. Montrond. Mr. Montrond states that his counsel was ineffective in failing to present available evidence that he was intoxicated at the time that the firearm that he said he was playing with discharged and killed Carlita Cheney. The available evidence the jury did not hear was testimony from Officer Ford. Officer Ford was a trial witness. He testified before the grand jury that when he first responded to the scene of the shooting, and encountered Mr. Montrond, he stated, quote, that Mr. Montrond, quote, reeked of body odor and alcohol.
Ms. O'Brien, was there anything else that counsel could have offered other than that observation by the responding officer? I wasn't sure that there was anything else in the record.
Well, there was nothing specific regarding alcohol or intoxication, but there was certainly evidence that could have supported that. The defendant's actions following the shooting could be seen as bizarre. He was banging his head against the wall. He was kneeling and praying before the body of Carlita Cheney. So there were things that were consistent, but certainly nothing as specific as the testimony of Officer Ford would have been.
But before Judge Troy, who was the trial court judge,
Yes.
on the first motion for new trial that was brought,
Yes.
there were affidavits of the defendant and I don't recall this man's name, who said they'd been out drinking that night. And Judge Troy chose not to believe those affidavits. And I noticed in the hearing that was held before, I don't remember who the name of the judge was.
McGuire.
Sorry, was it Judge?
McGuire.
McGuire, it was Judge McGuire. No questions were put to counsel about whether he had spoken with, the other man who said he'd been out drinking, or as to any family members who he did interview, he said he interviewed, about whether or not they noticed any alcohol scent or indication of drinking, and I just wondered why that was.
Why the questions weren't asked, I'm not sure I can answer that
On the motion for
question.
new trial hearing.
Yeah, there was nothing about this. There was nothing as to whether or not,
Well, perhaps I neglected that, probably should have asked the question, but nevertheless, I'd suggest that the defendant's claim that he was intoxicated, that his friends claim that he was intoxicated, really can't measure up to Officer Ford's testimony that he was
well, the body odor
intoxicated.
reeked of body odor and alcohol. That's
Yes.
just one person. I mean, there were all these other people who saw the defendant as well.
But it's very difficult to minimize the importance of that testimony would have had. And I'd ask the court to consider if we simply heard someone make that type of statement. Well, I encountered Mr. Jones the other day, and he reeked of body odor and alcohol. we would know exactly what's being conveyed by that statement. We would know that this person is saying that Mr. Jones was drinking.
Not necessarily. I mean, just because a person reeks of alcohol, that doesn't explain the extent to which that person's motivations or intent or behavior might be influenced by that. We have nothing in this record that I can see that would suggest anything other than he was drinking. We don't know how much, we don't know over what period of time, we don't know what he was drinking, and none of that is here.
But I'd suggest that an ordinary person would take that to mean the very word reeking. Someone reeks of alcohol. What's being conveyed by that is that this person has been drinking, and not just a little bit.
Well,
so that's
Ms.
the
O'Brien,
ordinary.
Let's just give you that for a moment.
Yes.
If we could, please. And that there would be evidence that could have been used in a closing argument and been marshaled as it related to manslaughter.
Yes.
Just give you that. Why isn't it within the strategic decision of defense counsel, and perhaps after consultation with the defendant, to decide, well, number one, I don't want to really stress that. I don't really want to present that type of evidence because it's inconsistent with an acquittal, and it's going to augment the Commonwealth's argument on second-degree murder as it relates to the third manner of intent. And so, therefore, as a strategic matter, I don't think I'll go there.
Well, Your Honor, this is exactly part of my point. To say that that evidence might have led to a conviction for second-degree murder rather than first-degree murder is an important recognition. It's part of the point that I'm making here about why that evidence was so critical in this case. And for defense counsel, now defense counsel's testimony, and I'd suggest defense counsel was quite open. He was balanced in his testimony. He wasn't falling on his sword, but at the same time, he wasn't overly defensive. And what he said was, yes, during the evidentiary portion of the case, I was going for all the marbles, was I think the term that was used. But he acknowledged that later on, he did ask that the jurors be instructed on involuntary manslaughter, and he did argue that briefly.
But really only in passing.
He argued it in
Like
passing.
a couple of sentences, really. I mean, he did not focus on that argument.
I'd ask the court also, well, he seemed to, he said something to the effect of maybe I should have, and acknowledged that was hindsight. So there was an acknowledgement there, at least by the end of the case. And I'd ask the court to take into consideration, I think it's worthy of some consideration, that Judge McGuire considered this, heard the testimony, and determined that this was, even though he credited counsel's testimony that this was a strategic decision, he found it to be, he stated that it was, I'm sorry, I'm looking for the exact term, manifestly unreasonable.
Now, we're not bound by that, though. We can look at this ourselves.
Yes, I understand that under 33, the court will consider all of those findings. But nevertheless, I'd suggest that Judge McGuire's, that finding is absolutely reasonable, even though I'd suggest that the judge seemed to add 2 and 2 together to find that this was the only evidence. He found that this was the only evidence available that could have given some explanation for how the defendant could have made this horrible error of not knowing that the safety was disengaged. But then he also said, quote, "There was no evidence that was presented that explained why the defendant might not have realized that the gun was able to fire." He recognized that the evidence would have supported both the accident defense and would have supported a conviction for involuntary manslaughter. So,
Can I just ask a question here? I guess I see that, but I don't see that evidence in any way going to the more fundamental, to me, question of what he was doing, pointing a gun, loaded gun, at his ex-wife, the mother of his children, within a very short distance away. The fact that he might or might not have known that the safety was on isn't really a full explanation for what probably would be deemed carelessness no matter what.
Yes, and that's a good deal of my point, Your Honor, that there is such a vast difference between being convicted of involuntary manslaughter, even being convicted of second-degree murder, where one has some hope of not dying in prison. There's a vast difference, and this evidence of intoxication could have made the difference, and I think that's implicitly recognized in Judge McGuire's, not only in Judge McGuire's decision, but also in the trial judge's decision. The first judge, the trial judge, of course, denied the motion for a new trial. But at the same time, he said, inconsistently, I suggest, evidence that Montrond was playing with a gun while intoxicated may have led the jurors to conclude that he was reckless. So that would have supported a conviction for involuntary manslaughter. I'm sorry.
You go ahead.
Wouldn't have detracted, though, from the accident defense if you had really focused on the intoxication? And, hindsight's great because it's a perfect science. But the problem is that this defendant may have actually done this by accident and wanted to seek an acquittal. And now here we are afterwards with hindsight being 20/20, and it seems to me that intoxication would actually make the accident defense more difficult because it would inevitably lead into more of either what we used to call third prong of malice or involuntary manslaughter.
Which is a good deal of the point that I'm making, that the jurors should, with that testimony regarding intoxication, the jurors would have been far more likely to see that there's reasonable doubt that this defendant actually did not know that safety was disengaged, and would therefore be more likely to convict of a lesser charge.
Could we go back to the motion, the hearing before Judge McGuire? So
Yes.
who testified there?
Trial counsel testified.
He's the only person.
He was.
So I guess I'm back to Justice Lang's question, because, and Justice Hines to start, but if that was the only evidence, I mean, I'm just not clear why in trying to show that it was ineffective, you weren't asking questions of the family members or what other people who observed him that night, or something like that, because it just seems to me if that's the only evidence, it's a pretty slim reed on which to build this.
I'd suggest that, Your Honor, that the power of that coming from a police officer who's a trained observer, who the jurors are going to believe, I'm asking the court not to underestimate the power of that coming from a police officer. It would have been believed. I suggest it would have been believed by, and I'd
Don't you
I'd
think it
ask
would
the
have been
court to-
undercut by the fact that nobody else testified to that?
There was,
And that would have been a powerful thing
explored.
to argue?
Well, it
Who
was.
else saw that?
Yes, there would have been, there would no doubt have been that argument, that the family didn't, there were family members there, they didn't testify that he was intoxicated. The family members, and I don't want to appear to be excusing in any way the behavior of the family members who didn't call 911 immediately, but nevertheless, not nevertheless, but I'll say at the same time, this family had to be, there had to be just pure horror occurring at that time. So the observations of the family in comparison to the trained observer, the objective observer, I'd suggest that the power of that testimony really can't be
Can I ask a
and should
question?
not be underestimated. Of course, Your Honor.
Now, we have a different standard, right, that we're looking at it under.
Yes.
Will it Do you think that makes a difference here for us?
Yes, excuse me, yes, I do, Your Honor. I note that Judge McGuire applied the standard in holding that the defendant was not entitled to relief. He stated, "The defendant has not shown a reasonable probability that the alcohol evidence would have changed the verdict." Of course, that's not the standard here. The question is whether the court can say with substantial confidence that absent the error, and I'd suggest there's no doubt that it was an error, that absent that error, the verdict would have been the same. And that's under the Commonwealth v. Wright and Commonwealth v. Spray. And so when you take into account that there's general agreement, there was the trial judge's statement that the intoxication could have led to, intoxication could have been evidence of recklessness, even the prosecutor's statement that it could have supported a conviction for second-degree murder, and Judge McGuire's statement really to the same effect, that it could have been evidence of recklessness and supported a lesser charge.
I turn you to a different subject with regard to the gun itself.
Yes.
I gather when the gun was found, there were 6 bullets in the magazine and
Yes.
1 in the chamber.
Yes.
The magazine holds 7, so one can assume that one of them was the one that was fired. But apparently, it only holds 7. Apparently, it's not so easy for the gun to hold 8 bullets, which it apparently did at the time. Was there any discussion during the ballistics testimony as to whether or not, if there had been 8 bullets, I guess there was testimony as to how that would happen, or how it could be done, as to whether or not the gun could discharge without the safety being, or if the safety was on?
The ballistics, the expert testified that the gun was fully loaded, so that means that that means, of course, that all of the gun was loaded to capacity, including a round in the chamber.
Apparently
and that
beyond,
the gun would
beyond
not fire.
capacity, I gather. I mean, beyond the usual capacity.
It's actually, no, that's not.
The gun actually held 8?
The gun can actually hold 8, 1 in the chamber and 7 in the magazine. And there's a way of loading the gun in that manner. I'm not sure, I'm being careful because I'm not certain that the expert explained that, but yes, there's a way of loading the gun where there'd be one in the chamber, the magazine fully loaded, and the gun could not fire with the safety engaged.
And when the gun was found, was the safety on or off?
The safety was found on. It was handled by at least the mother of the defendant and possibly the father as well. So,
Because
and
they
there
were
was
getting out of the
testimony that the safety was very easily engaged or disengaged. So,
And was there testimony that they had done something to the safety, that they knew enough to put the safety on where it had been off?
no, there was nothing like that. There was nothing. Oh, you mean about the knowledge of the?
Well, the safety was on when it was found.
Yes.
And you're telling me that there was no dispute that the gun could not fire if the safety indeed was on.
That's correct.
So was there any testimony that anybody had done anything to the safety to move it from the off to the on?
No, there was no explanation that was given.
Was there any evidence about the defendant's familiarity with weapons?
There was no testimony about his familiarity.
What about the testimony about his prior conviction, or his, I'm sorry, not his prior conviction, his arrest?
The mass most wanted?
Well, mass most wanted connected to the fact that the officer in the, was it South Carolina? Testified about the arrest, and there was a stipulation of some sort. Could you go into that, please?
I don't.
Are you claiming that that was error still?
Actually, I had planned to ask the court's attention more to the testimony of the medical examiner, Your Honor. I am suggesting that the mass most wanted testimony was error, but I noticed, of course, the court's opinion in Goddard, the decision that recently issued, where the psychiatrist or psychologist testified that the defendant intended his actions on the day of the murder. And I just wanted to point out that as to a medical examiner, it is settled law that the medical examiner cannot and is not qualified to testify to the manner of death. And in this case, the medical examiner insisted on testifying that this was a homicide as opposed to an accident, very close to the circumstances in Lannon, which is still good law and which was cited by the court as within the past 2 years. That's good law.
There was pretty extensive cross-examination on this point, though, wasn't there?
Well, it was certainly enough cross-examination that the medical examiner was able to get across the point that she was determined to get across, which was that this was homicide as opposed to an accident, which the ordinary juror would take to mean.
And the
not an
judge
accident.
didn't at any point interrupt that?
No, it was never struck from the record.
And there was no objection?
No objection. Defense counsel sought to minimize it, but didn't succeed in asking that it be struck, didn't get an instruction. So I wanted to be sure that that issue is not overlooked.
Are you suggesting that that was ineffective assistance of counsel?
Not to move to strike and not to ask for an instruction.
Right.
Yes.
Okay, thank you.
Thank you, Your Honors.
Good morning.
Good morning, Mr. Schulis.
Mr. Schultz for the Commonwealth, Plymouth County. If I could pick up with that last question, I just want to point the court's attention to the fact that the question regarding the homicide evidence was on recross-examination. And I'd like to point out to the court, it's not in my brief, but it is in the transcripts that trial counsel had asked that question of all the experts in this case. Whether, and he was trying to, as he said at the hearing, he was trying to elicit the fact that you couldn't tell from the path of the bullet whether it was accidental or intentional.
So what did the other experts say in response to that question?
I was focused on Dr. Hull's testimony, but he did ask that question. I don't believe they were qualified.
Who were the other medical
There
experts?
were ballisticians testified, the blood stain expert also testified, and the questions were asked of those experts. Here we're talking about the medical examiner, so she was actually qualified to, or she answered the question where I don't believe that the ballistician or the blood stain expert.
Are you suggesting that it was put aside what you've just said, but just out of the blue, is that a proper question to ask a medical examiner?
Well, his intent, and you can see from the exchange, and it's in my record appendix, you can see from the exchange that trial counsel was trying to get across that the question was, could you tell from the path whether this was accidental or intentional? Her response, in her opinion, this was a homicide. Trial counsel immediately asked her, did you understand my question? I don't think he was expecting that response. He didn't ask her, was this a homicide? He asked, could you tell if it's intentional or accidental? He was asking for a yes or no answer. When she said she didn't understand the question, he rephrased it, could you tell from the path, from your experience, was this accidental or intentional? Yes or no. He narrowed her in, and she said absolutely not. He rephrased the question again, asked from,
She said, I couldn't tell?
Absolutely not. Twice, she said absolutely not. So he didn't ask, was this a homicide? That was not the question he asked. The question he asked, it's in my record appendix, from your experience, could you tell from the path of the bullet, or could you tell from the direction whether this was accidental or intentional? And it was a proper question. The response was improper. I suggest it's not ineffective to move to strike or to object because he clarified his question and she clarified the response twice, said absolutely not. And there's case law out there that an expert's testimony that something is a homicide does not mean it's an intentional killing. It's a homicide. It doesn't. There is case law out there.
If it's a homicide, it is not an accident, and the defense here was accident. So it seems to me
a homicide is a killing, but here counsel clarified his question to her. He directed her. There would be no purpose in having her move to strike the question and answer. He had made his point and actually had focused her and had her make his point that she couldn't tell based on her experience, her training, her medical training, that she could not tell.
But that was before, she said all of that before I guess it sounds like she was frustrated with the continued questioning, and she added to the last answer, it was homicide, not accident. Isn't that
No,
the
no.
sequence?
No, the first question was, could you tell from your training and experience whether this was accidental or intentional? And she responded, in my opinion, this is a homicide. Counsel immediately said, did you understand my question? And she said no. I don't have the direct, I have it in my brief. I apologize, I don't have it right in front of me. Excuse me. She immediately asked her if she understood his question. She said not particularly. He rephrased the question and asked whether the direction of the bullet took or the path that it followed allowed her to tell whether it was intentional or accidental. She responded in her answer, absolutely not. He then asked again, okay, now from the distance you've suggested to us, and continuing on from, am I correct in saying that you can't tell whether the shooting was accidental or intentional? And her answer was absolutely correct. So he clarified the point he was trying to make, and that was that she could not tell, given her experience. So I hope that answers the question there. I'd like to back up to a little point, if I may, just quickly before I forget, about the testimony. I think, Justice Gantz, you may have asked whether or not there was testimony about the safety. So what we understand here is that the victim is shot, the gun's on the floor, the parents run down, father sees the gun on the floor, points to mom, says, grab the gun and hide it. She takes it and hides it in a closet. And then later on, when the officer arrives, he asks where the gun is. The father had hidden it in I believe, in a cabinet in the kitchen. He provides it to the officer, and the safety is on. Both mom and dad testified that they didn't push any levers at all on this gun. So what that infers is that this defendant, after shooting this victim, put the safety back on, which suggests to this court, and I would suggest, that he has the presence of mind to understand what's going on, in the presence of mind, to understand the danger of having a loaded firearm in the presence of others on the floor without the safety on.
Did the prosecutor make that argument at trial?
I don't recall if that was in the closing argument, but I'm suggesting it's a reasonable inference. The evidence
No,
is there.
I hear you. I wondered whether that
I don't
it
recall.
got presented that way, yeah.
I don't recall that in the closing argument. I could go back and look. But it's reasonable to infer if the only two people to touch the gun since the defendant shot the victim is mom and dad, and both testify that they didn't touch any levers or anything on the gun, and it's found with the safety on, it's reasonable to infer that the defendant put the safety on.
Well,
And-
that certainly is strong evidence for the Commonwealth, and goes to the weight of the evidence, for ultimately was a first-degree verdict. But that doesn't detract in any way from the defendant's argument that it was ineffective to not focus more on intoxication. That doesn't help the Commonwealth's argument for today.
So what does help the Commonwealth's argument is the recent cases of Commonwealth v. Epps and Kolnovic, where we talk about the manifestly unreasonable test. And was counsel's choice here manifestly unreasonable?
Isn't that, but Judge McGuire said it was. Is that right?
Respectfully, I disagree with Judge McGuire. His ultimate conclusion was correct, but I don't believe that this was a manifestly unreasonable decision, and this is why. Alcohol would not have helped an accident defense. Under Commonwealth v. Figueroa, we know that alcohol a lesser degree of alcohol consumption, lesser than debilitating intoxication, a person can still form the necessary intent for deliberate premeditation. That's Commonwealth v. Figueroa. And Commonwealth v. Stewart, we know that that a person's ability to form the intent for deliberate premeditation is not weakened by alcohol consumption. The only time alcohol consumption plays any part in a defendant's ability to form the requisite intent for deliberate premeditation is when his intoxication is shown to overbear or his ability to form the intent is overborne by alcohol.
Isn't that the point, though? Isn't really more the point that the jury had to decide between narratives here? This was either done out of, pique with her for having turned him in, which was the motivation that the Commonwealth was offering, to explain why he would have shot her, versus he was playing with the gun, which was a pretty stupid thing to do under any set of circumstances. And even if he was just buzzed and not debilitated, wouldn't that explain something?
So alcohol doesn't get you there. The introduction of alcohol would lead a jury to conclude that the defendant's inhibitions to carry out his intent to deliberately premeditate murder were
Suppose he
lessened.
didn't have that intent. Suppose he didn't have that intent.
So
Suppose
that's
the narrative they have to choose between, right? Either one, that was his intent, or he didn't have that intent. He was just playing with the gun.
So you look at the circumstances of what occurred, and what did the defendant say? This is an accident, this is an accident, this is an accident. So when you're trial counsel and you're trying to decide your defense, and you've done a full investigation of everybody there after the scene, and everyone's saying accident, 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 he's telling mom accident, he continues to tell his family members accident, he continues to tell his brother accident, he continues to tell his sister accident, and everybody who will listen that it's an accident. And I would suggest that his actions after the shooting was not bizarre, indicative of intoxication. As trial counsel said, they were indicative of someone who's distraught. And I might add in, everybody else there is acting the same way as the defendant. His mom and dad said the scene's chaotic, they were distraught, everything was crazy, crazy, crazy. Everybody's acting the same way. And counsel has to make a choice. Defendant's statements after the shooting was that this was an accident.
Yeah, but-
no one says he's intoxicated,
Not intoxicated. You don't even have to be over-the-wall drunk. I mean, you could just be buzzed.
but alcohol does not get you to
But it
lessen the
explains why
degree
you'd
of
be
intent.
careless. Wouldn't it be explaining why you'd be so careless to even do this?
Actually, Judge, most respectfully, I think it explains the opposite. It explains why your inhibitions to carry out your intent to kill are lessened. Under Commonwealth v. Stewart, under Commonwealth v. Figueroa, it explains why someone who has the intent to kill, their inhibitions to carry out this intent would be lessened. So accident doesn't get you there. Alcohol doesn't get you there. Accident gets you to, if the jury believes that this is an accident, because everybody's saying it's an accident, and he's telling everybody it's an accident, it gets you to complete acquittal. And as the trial counsel argued in charging for an involuntary manslaughter instruction, and I note under Commonwealth v. Tolan, it talks about there are circumstances where a defendant was found guilty with, with a firearm of involuntary manslaughter. And Commonwealth v. Tolan would support the defendant's request for that involuntary manslaughter instruction. He did receive the instruction. This is not like Commonwealth v. Horn, where we don't have an instruction here. So I would suggest after trial counsel's testimony at the evidentiary hearing, where he said he was not going for an alcohol defense because it would weaken his accident defense, I would suggest that that was not manifestly unreasonable.
Well, I mean, she was shot at very close range,
Correct.
correct? How many inches away was the?
I believe the testimony was from 2 inches to 2 feet.
Okay, so this is not somebody who is loading a gun and mistakenly fires it. This is somebody, I mean, it seems to me that he's pointing the gun at her head, and either he's doing it to kill her, or he's doing it because he's going to imagine what it is. She's so angry at her, he's going to imagine shooting her and basically says, pow, and then doesn't realize that the gun safety is on, or that arguably there was some way for that gun to fire, and then suffers this incredible remorse, and he characterizes as an accident. We would say it's at best reckless manslaughter. But I mean, it doesn't seem as if there was realistically an accident here. It's either that he was reckless in pointing the gun and pulling the trigger, or with the intent to kill or not. So I mean, it seems as if the only real defense here was involuntary, not defense, but the only real mitigation would be involuntary manslaughter versus premeditated murder. And that's why I'm concerned about the bullet in the chamber, as to whether there's any consequence to the bullet being in a chamber in terms of it firing.
So regardless, and I could speak to that, my recollection of the testimony was that it was yours, was that there was too many bullets for the gun to hold. And I believe the ballistician said, you know, with the safety on, the trigger wouldn't pull, so whether or not the gun was overloaded, it still would not go to whether or not it would fire. I don't believe there was any testimony on, actually, let me take back. I think there was testimony that the gun was working properly. There was too many bullets in the chamber, and I think, as you stated, there was a way to get that 8th bullet in the chamber, but it still doesn't go to whether or not the gun would fire, and so that would come down to whether or not the safety was or was not engaged.
Well, no, why, I guess I'm missing a step, though. If there's too many bullets in the chamber, forget the safety. Wouldn't that make it so you couldn't fire it at all?
I don't believe that was the testimony. In fact, obviously, it did fire.
Obviously it did. That's why I'm confused by it.
So I don't recall whether there was any specific testimony on that. I think the testimony was that the firearm was working properly, there were too many bullets in the chamber, but there was never any question on whether or not it was operational or functioning properly. So the question was the safety on or off, and how could the gun fire with the safety on? And of
I
course,
had thought it was that the magazine was filled, and you can't load it in the magazine. You'd have to load it directly by putting it into the chamber.
Correct.
That's the 8th bullet, is the bullet that was put not in the magazine, but directly into the chamber.
Which would suggest
Okay,
deliberate premeditation.
and you're saying
at least.
that the way the safety works, and I should know firearms better, is that that would have no consequence on whether or not the gun could fire without the safety.
I don't recall whether that was a specific question. I could go back and look at the transcript, but I don't think that was a contested issue at trial. I don't think that was a concern. The concern was whether or not the firearm was operational, working properly. And in this case, it was.
Was there any evidence, I asked your sister about this, was there any evidence about the defendant's familiarity with firearms, or whether it would, or did the ballistician testify in any way about what it would take to put in, that it takes a degree of familiarity to put that 8th bullet in the chamber or in the weapon?
The defendant did not testify, and I don't believe any of that evidence, there was no evidence of it.
So none of his family members testified as to where this gun came from, or whether he had any familiarity with it?
Not to my recollection, Your Honor, no.
And what about the other evidence as to the crime for which he was arrested in South Carolina? Was there any evidence suggesting that that was a crime involving the use of a gun?
None before the jury, Your Honor. There was a motion in limine the Commonwealth sought to bring in that evidence about the mass most wanted. The defense sought to keep it out. There was a weighing by the trial judge on the prejudice versus probative, so the judge allowed the testimony in that the sister had seen the defendant on mass most wanted. And as the trial judge noted in his opinion denying the first motion for new trial or the initial motion for new trial, that was strong evidence of motive if someone was on mass most wanted. But he did preclude any testimony regarding the circumstances of that prior offense. So he did allow it in as motive evidence. He did allow it in to rebut a claim of accident, but severely limited the Commonwealth's ability to talk about that other offense.
Going back to the accident theory, was there some evidence during the trial that the victim was lying down on the couch under a blanket asleep?
The testimony from, I believe it was the bloodstain expert, he testified that she was laying down with her head against the armrest of the couch when she was shot, and that the blanket was higher up on her than in the crime scene photos. And I would suggest to the court that would seem to me that the crime scene photos depicted her with the blanket moved down a little bit. And there was testimony that the defendant's head was on the couch, and this was from the experts testifying that
The victims.
when the victim was shot, her hair was protruding out through a hole in the armrest of the couch, so her head must have been on the couch when she was shot. And the testimony, when they pulled her away from the couch, her hair was pulling away through that hole from the couch. In addition to that, the defendant's mother testified that she had seen the victim laying down prior to, about 30 minutes prior to the shooting, I believe it was, 15 to 30 minutes prior, and when she came down after the shooting, victim was in the exact same position as she was prior to. So that evidence
Wasn't there also
suggested.
evidence that she'd taken Vicodin or some sort of sleep-inducing agent?
So the defendant does challenge the fact that the medical examiner did testify to the numerical results that she received back when she had toxicology screens done on the victim. And the Commonwealth agrees with the trial judge that that was testimonial and was subject to confrontation clause. However, it's the Commonwealth's position it was harmless error to admit it because the doctor's testimony, opinion testimony, asked afterwards that the Klonopin creates an analgesic, cause drowsiness, but it really was never contested on whether she was laying down, whether she was asleep, or had her head on the armrest. So Commonwealth suggests that was harmless error for the medical examiner to testify just on those numerical tox screens. That's the only thing that was really in error. Her opinion testimony afterwards was proper opinion testimony subject to cross-examination. If I could just point something out that's been repeated here, and it was repeated by the motion Judge McGuire, and I'd just like to clarify. The statement that was that trial counsel made a decision not to elicit during trial was that when Officer Ford encountered the defendant, he had a blank look to his face. Around his eyes were a reddish color. He had a stained T-shirt on. He reeked of BO, like sweat and BO, and alcohol. The defendant suggests that that means that the defendant reeked of alcohol. Commonwealth suggests he reeks of BO. He reeks of BO, like sweat and BO, and alcohol. That is not reeking of alcohol. It's some suggestion of alcohol maybe on a stained T-shirt, maybe coming from the defendant, but it's certainly not evidence of intoxication. It's no evidence of when the defendant drank alcohol, if any. It's a half an hour or more after the murder, and he's got a dirty T-shirt on. So I would suggest that that is in itself insufficient to, it goes to the counsel's reasonableness in not presenting it, because I think one of the justices said this is a very thin reed to lay a defense on. The suggestion of an odor of alcohol combined with sweat and BO is not enough to support a defense when you have everybody at the scene, including his family members, including medical personnel, including fire personnel. Nobody is saying the defendant had drank alcohol, smelled like alcohol. There's one small reference that he stunk. His T-shirt stunk. It smelled like sweat and BO and of alcohol. We don't even know how long he had the T-shirt on or how, we don't know any of those facts. And I would lastly point out that the defendant did abandon, after the motion for new trial, when she presented two affidavits, one by the defendant and one by his best friend, Anthony Goodwin. When the judge discredited those affidavits, and he was the trial judge and he heard all the testimony, the defendant abandoned those claims on appeal. And I would like to note that Anthony Goodwin happened to be the person the defendant called after he shot the victim. He did not call 911. He called his best friend, Anthony Goodwin, the same Anthony Goodwin who provides an affidavit later for him at the motion for new trial, the same Anthony Goodwin's affidavit that the trial judge discredited. I'd just like to point that out to the court.
Okay, thank you.
Thank you, Your Honors.